Here, we did that? Okay.
Yeah, and if ever you need the volume changed on your headphones, I can bump you down. And I'll give it like another 10, 15 seconds and I'll cut to you.
Good afternoon, everybody. This is The Lawyer Show. I am your lawyer, Jeremy Rosenthal, and thank you for watching. Thank you for tuning in. Those of you who are dedicated watchers or watcher, there can't be too many of you out there. Hopefully you get a feeling for the flavor of what this show is. I remember when I was a waiter at Chili's, many of my life experiences came from being a waiter at Chili's, and my family knows this, and people I work with know just the importance that experience played in my life. And we would be in the back and we'd be joking about people, making fun of them or not, complaining about tips, complaining about the boss, things like that. And I think being a lawyer is kind of fun, and we have a lot of locker room talk, which I kind of want to, I think everybody might find that curious. They might find it interesting. One thing I did promise, I'm not allowed to talk about my family or the people that I live with. It has been explained to me that that is off limits. So I am not talking about my family. There is one person, may or may not be family, who may or may not be 9, who wanted me to show off my socks today to the audience in the first portion of this. Can you pan out? Am I doing this? Oh, I'm not used to doing this. But there's a gavel and there's some scales, and these are lawyer socks. My guest today, my co-counsel, is attorney Karen Fitzgerald, and she is an employment attorney. I'm not expecting you to show your socks to everybody.
Good, thank you.
Yes, and this is probably the type of behavior that gets employers in trouble, I'm guessing.
It can.
Yeah.
You should assume that people don't want to see what's under your clothes.
Well, is that really under? I mean, my socks are...
Socks are semi underpants and undershoes. There is a gap between the pants and shoes, but just go with assuming people don't want to see.
Is there any federal case law, anything coming from a 12b6 or a summary judgment motion where socks were litigated? Has this happened?
I haven't had that in any of my cases yet, but that doesn't mean it won't happen. It can come any day now.
Well, hopefully not from this. Hopefully not like, and our viewers, I don't think they have standing to say, I mean, they've got an off switch. They just.
They're not employees.
Right, exactly. So let me introduce Karen just a little bit, and then I'll let her introduce herself. So Karen is an employment lawyer, and what Karen does that is different and that is unique is, or I should say tougher, is Karen represents the employees. And as lawyers, we are like piranha in the pond. We get money. That's what we do, because I don't shop at the free Kroger. I don't think Karen does either. And a lot of our laws are set up to where lawyers ought to get paid, because, again, the highest calling that there can be is your lawyer getting paid. And employers tend to be able to pay a lot more to lawyers than employees do. So lawyers who represent employees have the dual challenge, number one, of making it work financially, and number two, they get a lot of very mean, aggressive lawyers that they see on the other side of the table that are very well funded. So Karen does that practice, and I'm going to let you introduce yourself to everybody. My co-counsel today, Karen Fitzgerald.
Okay, thanks, Jeremy. I'm Karen Fitzgerald, and I am a solo practitioner. I have my own firm, Fitzgerald Law, and as you said, I represent individuals in employment disputes. And you do it for love. You do it for money, but you also do it for love, because this type of practice is challenging, but it's amazingly rewarding. I'm sure somewhat similar to what you do. And so I help people with I like to say I solve people problems. I help people with employment issues. And It can start at the beginning of the job. Everyone knows that first day, and you're given a stack of papers, or now, more likely, you're given a whole bunch of electronic forms to go through and click a box that you're signing and agreeing to all kinds of things like non-compete agreements, arbitration agreements, confidentiality agreements. Sometimes people actually get those reviews before they start the job, which is preferred. We recommend that. A lot of times when people are having trouble during the time they work at a company, I can help. And then, of course, if someone gets fired and they think it was for a discriminatory reason, or if it's just a layoff and they need someone to review the severance agreement, I can do that. So I represent the individual side. And yes, I do have a lot of well-funded opponents. But, again, you do it for love.
And so by that measure, you must have the biggest heart in all of North Central Texas, I'm guessing.
I think some would disagree with that.
Opposing counsel, maybe?
Perhaps, and maybe on certain days, even my husband.
Okay.
So I don't have the no family rule, so I can talk about him. But no, I think some might disagree. But, it's what we do is important. Just like what criminal defense lawyers do, we serve an important function of holding employers accountable and making sure they actually comply with these laws. So it's a really important thing to do.
Talk to me about, and talk to everybody about how your practice has evolved and how you got to where you are.
Yeah, so I started out in big law. As a baby lawyer, I worked for a big law firm, and I focused on what's called financial institution bonds. And so it was a form of insurance defense, so where you would have people steal money from either a bank or their company, and then the company would make an insurance claim. We would work on those. So it's kind of fascinating to learn the different ways that people stole money. And so I did that for about 12 years. And then some partners and I left and started our own little boutique law firm. And I kind of quickly realized there's a limited amount of that kind of litigation, and I needed to expand my horizons. And I had always been interested in employment law and just started doing it. And then I finally realized, oh my gosh, I've found what I'm supposed to do. I found my thing. I found what I'm great at, what I love. I've found what I'm supposed to do. So I had a small firm with a couple of partners for about 15, 16 years. And then several of my partners aged out of the practice, as we say, meaning they decided they wanted to retire and stop practicing law, which I can't really understand why.
Not me neither.
Yeah, but they foolishly decided to retire, and so I went to another small firm for a couple of years, and then last year, not knowing that a pandemic was coming, decided to start my own firm as a solo. And it's just so much fun.
Well, okay, so congratulations on all that. And so I'm interested to hear, so you did not, so your big law experience was not employment law.
No, it wasn't. It was kind of commercial litigation, insurance defense. Every now and then there would be an employment law angle in one of those cases, but it was not employment law. And I hadn't taken employment law in law school. I didn't think it was something I would like, but as I just started doing more and more of it, like I said, I fell in love with it. And representing individuals, as you know, they say attorneys and counselors. When you represent individuals, you are very much a counselor as well as an attorney. And so you have to be the right kind of person to be able to do that. It's much easier to represent someone who gets sued all of the time, so they know what's going on and what you're talking about. When you represent individuals, hopefully this will be their first and only engagement with the legal system. And so it takes a little bit more counseling and effort and hand-holding to kind of walk them through the process.
For sure. What we were talking off the air before this, when I was a baby lawyer decades and decades ago, I actually started out doing employment law and working on the plaintiff side of it, working on the employee side of it as you are. And I was lucky enough to work for a lawyer, we were talking about her too, by the name of Jeanette Johnson. She's now deceased. And so she did employment discrimination, and I worked for a couple other practitioners that did a little bit of this, a little bit of that, little non-compete here and there. When I left the DA's office, after I was a prosecutor, I was going to combine, that was my big idea, I was going to combine employment law and criminal law, and that didn't really, the two didn't really fit, because I'd have a judge needing me in court on a Friday morning on a criminal case, and I'd have some some family-friendly big law lawyer who would notice a deposition that morning that I didn't know about 2 or 3 days before. So the calendar's never mixed. But one of the things that I really found about doing employment law was the emotions run extraordinarily high, and in some instances, a lot of instances, I'd even say higher than in criminal law. Talk about how, and you're on the brunt of that because you're dealing with the actual employee, not HR.
Right. So, people's identity is tied to their job. So much of their self-esteem and their identity is tied to their job. And so to just suddenly lose that, often for reasons that you believe are discriminatory or unfair, it's a shock. And then aside from the blow to the self-esteem, there's a financial shock. The mortgage has to be paid. The rent has to be paid. The kids need to eat, and you don't want to feed them cat food. You need to buy groceries. You have all these financial obligations, and of course, a huge concern, particularly during the last year in a pandemic, is the loss of your group health insurance benefits. So in addition to the emotional shock, it creates so much fear for people to lose their jobs. And so it's very, very traumatic. And I think some companies just don't pay enough attention to that when making their decisions. Mm-hmm. And I tell people all the time, there's a huge difference between what's unfair and what's illegal. You learned that when you did it on the plaintiff side. Huge difference. And so much of what we see is what is unfair, but not illegal. But I have to sit back and think to the companies, like, what were you thinking? Mm-hmm. You could handle this so much more sensitively rather than in a callous way. And again, there's a lot of good companies out there. There are a ton of them. But it's such a brutal thing to have happen to people. They really, when they first reach out to me, often they are in shock.
Mm-hmm. I would find one thing that a conversation I actually had with several of my clients, and a rule that I made was, and again, because the emotions ran so high, and yes, you're absolutely correct that people's identity is wrapped up with what it is they do, and you do it all day, every day, and sometimes for a decade, and sometimes for 2 decades, and then one day somebody kind of follows a rule, maybe not really, and you're gone, and it can be a very, very explosive emotional experience. And one rule that I adopted after just a few times of having to go through the rules of ethics, mm-hmm. And the Texas rules for disciplinary conduct, and because I told people, if you make a threat to somebody, whether I think you're kidding or whether I don't think you're kidding, you're gone. You're not my client anymore. If you say something that I can construe as a threat against another person, because I can't tell you how many times I had somebody just kind of sitting there and muttering to themselves, I'd love to slash their tires.
Wow.
That doesn't happen to you?
That has not happened to me.
Okay.
Wow, that has not happened to me ever.
Maybe they thought I could help. Maybe that's what that was.
Well, maybe I just look scarier than you, and they're way too afraid to ever even utter those comments to me.
That has to be it. But I had clients who would say things like, who would not make threats towards people, but a few that would just obsess about their predicament.
Right.
And also, and you probably have seen this, even if you haven't seen any threats or any type of banter, but I'm guessing that you've probably seen people who, I'm going to blame that one person over there. It's the new manager, right? It's always the new manager.
It's always the new manager. Always the new manager.
They brought somebody else in, and I'm like, I see the whole face coming.
I joke about this, but with every new client, we walk through their story, and there's always a point in time, and then the new manager came. Mm-hmm. Always the point in time. The one thing, Jeremy, I have had happen is people threaten self-harm.
Okay.
Not threaten to hurt others, and that, raises its own mm-hmm. concerns. And there's a group of plaintiffs' employment lawyers in Dallas. And, we've talked about, what do you do when that happens? What are your ethical obligations? What can you do? Because that's really alarming.
Right.
But yes, going back to the new manager, it's always the new manager's fault. And actually, it always usually is.
Right. Okay.
So.
Yeah. Wow. You're watching JP, Kathy, and the Crew Network. This is the Lawyer Show. We're on between 12 and 1 on Thursdays. You can watch JP, Kathy, and the Crew between 7:30 and 9 on Monday, Wednesday, Friday. My co-counsel today is Karen Fitzgerald, employment lawyer. I am Jeremy Rosenthal. Okay, so kind of digging deeper into employment law and the different types of things that you do. We get a lot of referrals at our office. We get a lot of different calls. We only do criminal, but people, they if they only know a lawyer or two, I might get a call for things like this. And when I get a call for employment law, I always have to tell them what flavor. I have to ask them what flavor because there's a million. And people don't appreciate it. They think it's very one thing, but it is just astronomical how much is out there with employment law. Talk about what are your 2 or 3 bailiwicks.
Yeah, so any type of discrimination claim, whether it's race discrimination, sex discrimination, disability discrimination, and then, of course, any type of retaliation that flows through that. So I do a lot of work for women and represent a lot of women, and equal pay is one of my passion points. So I'm very passionate about always looking for cases to find out if women have been underpaid as compared to their male peers. Always looking for that. I do a lot of FMLA work. You know, if people need to take family and medical leave and they've been denied that opportunity, you know, that type of claim can be fun to pursue. But, you know, any type of discrimination claim, and frankly, everyone's favorite claim on the plaintiff's side is a retaliation claim, because discrimination is hard to prove. Judges don't love it. They don't like to believe that it exists, but of course it does. You know that. But retaliation, judges get it. Juries get it. Everybody knows you hate someone who's a rat. And so the minute someone has complained and they turn against you, you know, there's lots of, and I hate to say lots of good retaliation cases out there, but it's true. There are.
Yeah.
And then age cases. You know, as someone who's aging, the baby boomers as we get older, it's real. And it's going to be a big problem for a lot of people who got let go during the pandemic, trying to find jobs to replace it. So age discrimination is a big issue right now.
How does a typical underpayment, a female who is being underpaid relative to her peers, how does that present? What does it look like coming in the door? Yeah,
so a lot of times it's interesting because usually they will find out by accident. Unless it's someone who works for a public employer where salaries are publicly known, a lot of times they find out by accident. They just happen to be talking to a coworker who says something, and they find out, what? You know, my subordinate earns more than me? How's that working? And so, you know, they'll come in. Sometimes they have a little bit of information, and it's like, well, sometimes they know for sure. They've seen documents. Sometimes they don't, and we raise the points, and we have to raise the charge with the EEOC and say, look, I think I was paid less than, you know, a man doing the same job. And it's frustrating in the marketplace right now because what happens is companies aren't used to thinking about a job as, oh, this set of skills and duties is worth X. And they'll think, well, you know, the market is competitive, and so I hired you a year ago at X, but this guy's coming in, he wants Y, and I have to pay him Y if I want to get him. Well, once you pay him Y, those duties are worth Y. So you need to raise the female from X to Y, but they don't do it. It's kind of like the cable company or AT&T, and I shouldn't slam AT&T, but it's like, you know, once they lock in their long-term customers, they don't give them the same benefits that they give to the new people. And so it's kind of that same approach, and it happens all of the time.
And so the perpetrators of these can be bigger companies. Typically, what's the profile of your typical perp?
It can be large companies, but it can also be very small companies too. The smaller companies tend to have, they don't know that it's actually against the law to tell people they can't talk about their pay. And so they will have rules in their employee handbooks that says, oh, you can't talk about pay. Well, when that happens, we can go file a charge with the NLRB because that's an illegal work rule. People need to be able to talk about it. So it's really all sizes of employers, and it happens. It can happen when people just aren't paying attention and looking at, okay, in this department, we have all of these people. Why is this person paid that and this person paid $10,000 less? You know, they just kind of let it happen. And then you have percentage increases year on year and bonuses based on a percentage of your base salary. And that gap gets wider and wider and wider.
That would seem like a hard thing to, that would seem like a very administrative intensive case to build.
It can be, but not always. And so, you know, I'll give you an example of a case that just the Fifth Circuit just reversed a summary judgment. But a woman came in, and it's not my case, but I was reading the opinion. It was fascinating. So she was a food and beverage director at a hotel, and she was hired at a certain salary and found out that the 3 men who had been in that exact same position before her had been paid more. You know, and so she sued, and the district court granted the summary judgment and said, well, other than showing that it was the same job title, she didn't show they did the same thing. I mean, it's the same job. And so the Fifth Circuit on that one's like, it can't be any more the same job than that, and they sent it back.
Right.
But it's silly that you have to have that kind of fight. And it's like, you know, if it was worth $100,000 when the guy before me did it, why is it now only worth $90,000 if I'm doing it and I have comparable experience, comparable education, and things like that?
And that's got to be something that's really difficult for you on the front end, because if somebody's coming in and saying, I have a wage or I have an equal pay claim, and then you look at the person that she's comparing herself to, and well, I didn't. Yeah, they think they think there's something there, but then you're like, well, this other person's got 20 years on you, and that's going to be an issue when we get to court.
Right. And so sometimes, you know, you take those cases and it's a little bit of a gamble. Like some cases get better with discovery, some cases get worse with discovery. And you probably have the same thing in your stuff.
Yeah, except the difference is that you are underwriting the case in most instances because you're taking it on a contingency.
Right.
So whereas you come to my office, if you pay my fee, I love you. If you don't pay my fee, then you're not my problem. But
right.
in your instance, you are gambling to a certain degree.
Right.
That this other person's going to be there, and you can't expect your plaintiff to know that. I mean, they're not a lawyer. So.
Right. It's a gamble, and so you win on some, you lose on some. It's like going to Vegas. You know, you win some bets, you lose on some bets, and you hope you win enough on the ones you win to cover you for the ones you lose.
So okay, now I'm going to go off on a ridiculous tangent, but I'm going to come back to employment law and some of the intricacies of it, but. One of my dreams, and I've never said this on the lawyer show, on this. One of my dreams is to have a criminal defense practice in Las Vegas, because can you imagine the amount of crazy that people think? Because people go there thinking, oh, what happens in Vegas stays in Vegas. But you know what? You're going to get that call that. You know, my husband is the CEO of a company in New Jersey, and he woke up with a dead prostitute. What do we do? You're going to get that call in Las Vegas, right? I mean,
right.
And so the crazy just has to be off the charts. That's just my one. That, and I want to own a gas station in the desert. If I can do either of those things in my life, I think we're set. Okay. I
applaud you for wanting to take on that level of crazy. I prefer a little less drama in my life than that, so I applaud you for being open to that.
Okay, thank you. And let's get to one of the reasons why I sort of kind of veered away from employment law, but it's something that's very, very, it's pretty important. And we kind of talk procedure-wise, and I've equated this before to the Sesame Street. We want to be like a Sesame Street, not the Sesame Street. We don't have delusions of grandeur. I mean, we're not judges. But Sesame Street, just basic stuff, because sometimes we kind of talk about things that are pretty common for you and I. But procedure-wise, one of the things with employment law is that there are a ton of tripwires that are there either on purpose or not on purpose that can really screw people up. So I want to talk about a couple things just to kind of translate it down, because we've talked about it a little bit in passing. One is the EEOC and exactly who they are and what they do, and the other thing is what is a summary judgment, which I know is very basic for you and me, but my audience probably is what you think they are.
Right. Okay, so let's talk about the tripwires, because there are definitely a ton of them. For certain types of claims, before you can file a lawsuit, the way the laws are written, you first have to go through what's called the administrative process. You have to file a charge of discrimination with either the EEOC, Equal Employment Opportunity Commission, or the Texas Workforce Commission Civil Rights Division. And so certain laws are, apply to those types of claims. So any type of discrimination under Title VII, race, age, race, age isn't under Title VII, but race, sex, national origin, religion.
And that's titles, and I know this because Professor Armour at SMU would be so proud. I doubt she's watching. She's retired. Title VII of the 1964 Civil Rights Act?
Right.
Okay.
As amended. It's been amended since then.
So you got me. I didn't know.
Amended in the 90s. But so certain types of discrimination claims, you have to go through this administrative process. And the first tripwire is you have a short deadline to do it. If you want to preserve your rights under state law, you've got to file a charge within 180 days of what the law calls the adverse employment action. So whatever bad thing happened to you, you got fired, the date you didn't get hired, that type. So 180 days goes fast. If to preserve your rights under federal law, you have 300 days. There are other types of claims that don't have to be filed in front of the EEOC. But for example, if you're working someplace and your employer asks you to do something that would be unsafe, and you refuse to do that, and you get fired because you didn't want to do whatever unsafe thing they told you to do, like, go stand on this rickety ladder right below an electric wire and hold a metal pole up. If you refuse to do that and you get fired, you'd need to file a complaint with OSHA, the Occupational Safety and Health Administration. And that kind of claim only has a 30-day period. So one of the biggest tripwires is people wait too long to try and figure out if they have a claim. Mm-hmm. You've got to pay attention to your deadlines. Then the administrative process, like if you file a charge with the EEOC, it can be frustrating because the Dallas office is very backlogged and they can take years to investigate. But you can't sue on certain claims until you get a dismissal from the EEOC and a right to sue letter. If they haven't resolved your charge within 180 days after you filed it, you can ask them to issue you a dismissal and right to sue letter. And then once you get it, you've got 90 days to file in federal court. If you get one from the state agency, you've got 60 days. So those tripwires are everywhere.
Right.
And people who don't know employment law well miss them all the time. Mm-hmm. And like I said, OSHA, the 30-day one, certain other type of whistleblower claims, like say you work for a public employer and you report some type of wrongdoing. Another tripwire, say for someone who works for the state and they've been asked to do something illegal, is they need to report it to a law enforcement authority.
Sabine Pilot.
Well, Sabine Pilot.
Am I right?
Well, that's a different one, but close, so close. But
you didn't think I knew that.
I'm impressed. So Sabine Pilot.
But I'm wrong, kind of.
Yeah, Sabine Pilot is if you're asked by your employer to do something, and if you did it, you could be subject to criminal penalties. And if you refuse and they fire you, then you've got a Sabine Pilot claim. And so like say you work for a company and they need an affidavit signed or some type of financial statement signed, and you know that the stuff in there is not accurate and you have to sign it under penalty of perjury. Mm-hmm. And you say, no, I can't sign that because it's not true, I'll be committing perjury, and they fire you, then there's a claim.
Got it.
So first tripwire is all of these deadlines. And you know, they're different for every statute. You know, it's just a mess. But that's the first tripwire. And then the second thing that makes employment law so challenging, and I'll get to what is a motion for summary.
Because I've been waiting this whole time to hear why this is hard.
Oh, because it's people don't like it. They don't. You know, Texas is very employer friendly.
Oh, you think?
Yes,
you think that we like kicking people out of court here?
We do.
Yeah.
So,
Okay.
yeah. So a motion for summary judgment is a way for a court to dismiss your case before letting you go to a jury trial. The judge basically says, okay, you're suing for race discrimination. You know, all of the evidence you're presenting to me is not enough to meet the legal standard to even raise a fact issue as to whether race discrimination exists. So I'm going to kick you out of court on what's called a motion for summary judgment. And that's a really dangerous point in employment litigation. A good 60% of cases probably get dismissed on a motion for summary judgment. So what makes it so challenging is we have all of what I call judge-made doctrines on how to cause the plaintiff to lose.
Right.
So they put requirements in that aren't really written in the statute, but then impose them, and it's just so hard to meet them.
It's you're watching JP, Kathy, and the Crew Network. You can see JP, Kathy, and the Crew between 7:30 and 9 on Monday, Wednesday, and Friday. This is the Lawyer Show. We are on between noon and 1 on Thursdays. And so kind of to this point here, this is what I found to be fascinating between a criminal practice and employment law, because I was as a prosecutor, we're just trying a lot of cases. We're in front of juries constantly. And as a defense lawyer, we are as well. And what happens is in a criminal court, there's really no filter. The prosecutor brings a claim. They can file a misdemeanor case by what's called information. Just because I think you committed a crime, we're going to file it. A grand jury reviews cases and decides whether or not the case can be indicted in the case of a felony. But there's no motion for summary judgment.
Right.
We can't, you know, I have clients who say, well, can't you file a motion to dismiss? Well, that's called a trial. And so the evidence, and what happens too is the standard. And I don't know, you may or may not deal with Jackson v. Virginia, but Jackson v. Virginia basically says that the standards on appeal for factual and legal sufficiency are one and the same, which is fun to go argue in front of the Court of Appeals, because I say, why do we even need you people? If the jury convicted you, so really good, intense lawyer joke. I'm sure I had a lot of people on the floor laughing at that one. But what's crazy is, and I remember working with Jeanette Johnson, I remember listening to federal judges and state judges sit there and pick apart the summary judgment evidence and say, well, that's not evidence of discrimination, and that's not evidence of discrimination, and that's not. But in criminal court, if there's a lawyer friend of mine who said, if the monkey says it, it's true. You know, if anybody says, if there's any kind of allegation, and if it is remotely mentioned in the courtroom, the judge lets the jury have it in a criminal case.
Wow.
So there is no, and so the dichotomy, hypocrisy of the difference between what is evidence in an employment case when we're trying to take a job creator's money, right? Mm-hmm. And the difference between when we're trying to put somebody in jail, because in your instances, basically what you have in summary judgment, the judge is playing goalie and stopping a lot of cases from going to the jury.
Right.
Just because.
Just because the judge has made the decision based on this, there's not enough for there to be a fact issue. And it drives us crazy because, you know, employment, the decision to fire someone can be very subjective. And so if someone's intent is involved, that seems to be inherently a fact question. And so an employer's witness will say, I had a good faith belief that this person did X, and that's why I fired him. Well, and the judge is like, oh, legitimate non-discriminatory reason. Well, how do you know that that was a good faith belief? Mm-hmm. Just because they say it in an affidavit, shouldn't the jury get the chance to see that person, hear that person, and say, really?
That would be no different for just so people know, that would be no different than my client saying, "But I'm innocent," and then the
Right.
judge saying, "Well, okay, great,
done here.
I guess let's go, let's get lunch."
Yeah.
Which is a big deal too in criminal cases and jury trials.
Right.
But it's just a huge dichotomy.
Yeah, and so employment lawyers have started kind of pulling language from criminal cases when it talks about, proving intent, because it's like, wait, why is that standard okay in the criminal cases, but why are we using a different standard in employment cases? But it's really frustrating. So like one of the biggest challenges we have is in putting together what we call comparator evidence. One of the ways to show discrimination is to say, hey, I was treated differently than someone who doesn't look like me. Or, male, female. Female says, I was treated differently than the men. And the law says, not the statute, but the case law says, well, you've got to show that you were treated differently than someone that is similarly situated to you. Read nearly identical. Well, again, the statute doesn't say that, but that's what the judges say. And they're so granular. And so the example I always use is there was a case years ago where two men were fired, or one man was fired for stealing from his employer. African-American man, he sued for race discrimination. And he said, look, the white guy over here stole and he didn't get fired. And the court was like, well, he was accused of stealing from the customer and you were accused of stealing from the company. So you guys aren't similarly situated. So he's not a comparator, so you have no comparator, so you lose. And I just don't understand that.
And another thing that always baffled me was there's a bit of a tennis match in a discrimination case in particular, and I forgot, you're going to say the name of the case, and I'm ashamed that I forgot it, but it's the burden shifting.
McDonald Douglas.
Okay, so it's like the burden shifts to take us through the Mcdonald Douglas balancing test.
Yes. Okay.
Burden shifting.
So if anybody's coming into my office and said, I think I have been discriminated against, what I explain is we first have to make what the law calls your prima facie case. We've got to show you're in a protected category. So I'm in a couple of protected categories. I'm a female. I'm over age 40. And then I have to have suffered an adverse employment action. If someone fired me and then I was either replaced by someone not in my protected category or other people who did whatever it is I was accused of doing to justify firing me didn't get fired. So you make the prima facie case. Then the employer has to articulate what the law calls the legitimate non-discriminatory reason.
Okay,
yeah.
I remember that one.
Yeah,
okay.
I was going to say, you totally remember that. So the employer has to come up with a reason. Doesn't have to be a good reason, just some form of reason. And then once the employer does that, the burden shifts back to the employee to show, no, that was not the real reason. That's just a pretext for discrimination. And my age or my race or my sex was the real reason for it. And what I always tell my clients, think of it like a scale and you're putting bricks on a scale. We have to have more bricks on our scale to show this is more likely the reason than what they say. Mm-hmm. And so each fact we can have, like say it's a layoff and they say, oh yeah, the economy, we have to have this layoff. What's a layoff of one? That's a fact. That's a brick on my scale, right?
Okay.
Or if they say, oh, your performance was terrible, but I just got a stellar performance review the month before. That's another brick on my scale. Mm-hmm. And so that's, you have to show that what they've said is not really the reason to try and prove that the real reason was some form of discrimination. And judges just are not always open to that.
And if you manage to get it all the way through that, then you get to deal with the jury who is sick of the frivolous lawsuits.
Right.
Yeah.
Right.
And have you experienced any of that?
Well, some. So, the good news about employment stuff, like you guys are in trial all the time. Like our stuff, it can be really rare. So it may be years between trials. 99.99% of this stuff gets resolved. And then the other thing we have is more and more cases are being compelled to arbitration. So we're not necessarily having juries. And I'm actually an arbitrator for AAA, so I serve as an arbitrator too. And some employment lawyers hate arbitration. But I'm kind of like, well, when you have to go to the Fifth Circuit or the Texas Supreme Court, I might prefer my odds with an arbitrator as compared to those things. But yeah, people are very unsympathetic. Because it's kind of like, well, I got fired and they didn't have a good reason, and you must have been doing something wrong.
I just sucked it up.
Right. You must have been doing something wrong. Or say like you think you have a contract claim, an oral contract. A jury's like, oh man, you needed to get that in writing. Everybody feels strongly about that. So it's just kind of fascinating. But yeah, jurors aren't enormously sympathetic. But just in this past week, I think in Washington State, there was a verdict against IBM that's like $3 million in actuals and $6 million in compensatories, which are the mental anguish, emotional distress, which is really rare. It was a discrimination and retaliation claim. There was an ADA verdict, I think in Kansas, of $3 million, just pure compensatory damages.
I mean, this is fabulous news, not because I have an agenda one way or the other, but that there are lawyers on both sides getting paid very well. That makes my heart warm.
Right. Well, on those, remember, they haven't collected it yet.
True. The plaintiff hasn't. The defense has been paid.
The defense has
been paid, but they've got to file, like in Texas, don't you have to, I think, is it a supersedious bond?
You do, yeah.
If I get hit with a $3 million verdict, I have to put up like $6 million to the Court of Appeals, or so. Is that what it is?
I can't remember the numbers, but like I always tell my clients, it's like winning the trial is just like another inning in baseball. You still got several more innings to go, because then there's the motion for new trial, which is a dangerous time. Then there's the appeal. So there's lots of ways you can still lose after winning the jury trial.
And you never want to retire. This is, you're just like, man.
Okay. I love what I do. But as I actually am getting closer and closer to thinking about retirement, but not anytime soon.
Not anytime soon. Okay. I want to transition a little bit to a bit of a different area. Let's talk about non-competes.
Okay.
Because I also found that this was an extraordinarily employer-friendly area. But tell the jury what a non-compete is.
Well, so a non-compete is an agreement. It's a contract between parties where one party agrees that when the employment relationship ends, the employee will not do certain types of competitive activities. They won't go work for a competitor, or they won't try and solicit clients that they worked with. It's that kind of restriction. And I'm so glad you asked about it, because now you give me the chance to get on my soapbox. So many people in Texas have the misconception that a non-compete is not enforceable. And you will hear over and over and over, Texas is a right-to-work state.
No, it's a right to fire you because I want state. It's a right not to not work.
Well, right to work is different than at-will employment, and we'll talk about those. But people always hear, and if you Google it, you'll find, Texas is a right-to-work state. Your non-compete is not enforceable. Completely wrong. What being a right-to-work state means is that you cannot be required to join a union as a condition of getting a job. It has nothing at all to do with a non-compete. And so people, we do have a statute in Texas that allows parties to enter into enforceable non-compete agreements. And there's a couple of statutory requirements. And if the companies meet the statutory requirements, a court will enforce the non-compete.
Are you ready to be really impressed? Are you ready?
I'm ready.
You ready for this?
I'm ready.
Texas Business and Commerce Code 15, 51, 52, and 53.
I'm impressed. He knows his non-compete.
Microphone drop.
Yeah, you don't need to do criminal defense anymore.
Well, actually, no, we'll stick to our daytime job, and I'll let you deal with the mean defense lawyers and the Business and Commerce Code and the EEOC. Enjoy.
So the worst part about a non-compete is a lot of people think, well, even if they thought it might be enforceable, they think, well, I just got fired, so surely it's not enforceable when I got fired. No, it's still enforceable. And What's often challenging is people who are working for a company, and then a couple of years in, the company presents them with a non-compete and says, sign it or you're fired. And if they reach out to me, if they're at all worried about their job, I say, don't sign it. And then they'll say, well, then I'll get fired. I'm like, yeah, but you can sign it and they can fire you tomorrow. And then you're bound by the non-compete. The big issue with non-competes is they need to be reasonable in scope. And there's a lot of controversy going on right now about who should be bound by non-competes and who shouldn't. And so a couple of years ago, I don't know if you heard about Jimmy John's, the sandwich makers. They had all their sandwich makers sign non-competes. So if Jimmy John's fired you, you would not go down the street to Subway or Schlotsky's because you might share their confidential business information or trade secrets. And of course, I'm like, bread is bread. You take 2 pieces of bread, put some cheese on it, some form of mayonnaise or mustard, and a lettuce and tomato and a meat, and you're good. Why is that a trade secret?
Right.
But so they got a lot of pushback for that. But it's a big problem because a lot of people don't even know they're going to be asked to sign a non-compete until day one. And they're given all this new hire paperwork, and there it is.
It's right there in the middle. This is The Lawyer Show. We're on between noon and 1 on Thursdays. You're watching JP, Kathy, and the Crew Network. They are on between 7:30 and 9, Monday, Wednesday, and Friday. One of the things with non-competes that I never quite got my head around was because the theory is you're entering into a contract.
Right.
And that's what the law says. The law says, well, everybody can write it. And so you, Jimmy John's, and you, sandwich maker, you are 2 equal people on equal footing, and you guys can have a contract. One of the things a contract has to have is what we call mutuality of consideration.
Right.
Everybody has to get something for it.
Right.
Okay. And it's this ridiculous fiction that we're going to, and so that because we're not going to actually give you consideration, right? Employee sandwich maker, we're not giving you really anything.
Right.
You get access to our secrets.
Right. While you work for us, you're going to have access to our confidential business information.
Right.
And so you've promised to keep that secret. So now we have an agreement, and then, attached to that is this non-compete agreement.
And I get it. I get it if we are with Pfizer and we're working on the new mRNA vaccine for the mutated Texas coronavirus strand. I get that. That makes sense that we can't go and sell that recipe to Moderna or some other competitor and make hundreds of millions of dollars for them. But it's this fiction of you are getting our secrets.
Right. Yeah. And sometimes they get secrets, sometimes they really don't. Secrets is very broadly defined. So our business plans, our strategies, where are we going to go? And I think, the problem I see with non-competes is employers just get greedy and they don't take the time to write a thoughtful non-compete on the front end.
They get it on the internet.
Right. Could be. And so what I always tell people when they actually come to me, when they're asked to sign one and we're trying to negotiate it, it's like, let's figure out what exactly it is that your company is most afraid of you doing. And then let's write the agreement so you won't do that. We want you to be able to go and get a job. Obviously, always keep their confidential information confidential. Don't steal their trade secrets. But let's figure out how you can get a job in the industry so you don't starve to death while protecting their interest for a period of time to let relationships go stale, kind of thing.
I would say that probably the very last vestige of my employment law practice is friends and family members every now and again. Even still, I've got this non-compete. And so I've looked at that and I try to give it the grain of salt or tell them, it's only been a decade or so since I've since I looked at 15, 51, 52, or 53. I'm sure there's certainly some of the case law has made it
it's changed a lot.
Okay. You're okay. Yeah, so, but those are going to be the things I look at. But what I do see, I'll tell you this, you tell me what you think. When I do review some of those, I can tell when it hasn't been touched by a lawyer, when this was something we printed off the internet, or this was a Frankenstein of a friend of a business. People are sharing this, and I'm like, no, they can't keep you from going to Wisconsin.
Right.
No, they can't bind you for 10 years.
Yeah, my favorite are the worldwide, 5-year worldwide, all aspects of any business that we may have ever even thought about. Not that we're doing yet, but we just thought about it. So that's not going to be enforceable. But a narrowly tailored non-compete will be enforceable. But yeah, so most of the ones that you see that are just way overbroad, a court, the bad news is a court in Texas can reform it and so do what we call blue penciling it. The court can rewrite it and says, oh, that worldwide is too broad. I'm going to restrict you from doing that business here in Texas. And if you only worked for that company in Texas, that's fair, because then there's 49 other states that you can go work in that industry and you're not bumping into each other for a while. But that's the problem with those ones that just come from the internet or the employer hasn't thought about it in about 20 years.
The ones I've seen that have gone into litigation on non-competes, those get very nasty very fast.
Yes.
Talk about that.
Well, you said it, they get nasty very fast, because the employer is going to try and get what's called a temporary restraining order. So an immediate order that says, hey, judge, say this person can't work at this company. And then we have a full-blown hearing within 14 days. Sometimes we do discovery in between. And, it's whether someone's going to be able to work or not. And sometimes the new employer is sued as well. And so they're very expensive. Very fast. And for individuals, this is really the hardest part. They can't often fund the defense of a non-compete lawsuit unless their new employer is helping them. If you're going to go to a full-blown non-compete fight.
They're caught in the middle because what happens is, let's say, it's in the company list. There's another one that I'm sure I always heard of the company list a lot, our customers list. So let's say, okay, so just to give everybody kind of a broad picture here. So let's say I'm working at whatever, Consolidated Widgets, right? And I'm a sales rep for them and I've got their 500 customers. And then somebody from company X says, Jeremy, we're going to pay you a higher commission. We're going to do this for you. We're going to do that for you. You don't want to be on the road so much. We're going to do that for you. And let's just say they happen to be down the street. So and there's a negotiation period, right, where I'm kind of talking to them and I'm still working for these guys. And let me tell you what these guys do over here that I don't like. So there's that part.
Don't be doing that.
There's that kind of stuff. And then let's say I do make the jump.
Right.
Over there. What happens is company Y, what did I say? This was X. So company Y can sue both me and the new company.
Right.
And the new company can fight company Y.
Right.
You would think.
Right.
Has more resources to do it.
Right.
And they may say something like, well, we didn't know you had a non-compete.
Right.
But poor me or Joe Blow or whoever's in the middle there, I'm caught in the middle of very expensive lawyers lobbing nuclear weapons at one another.
Right. And sometimes the new company will pay for your defense. And sometimes they're like, well, we'll keep you, but you have to pay for your own lawyer. And it is extremely expensive. You can get to 6 figures really fast in a non-compete fight. And that blows people's minds. But, it just takes a lot of time and you're doing a lot of work. And so what I always tell people if they're thinking of leaving is leave the right way, which means leave everything behind. Don't take any of your former employer's stuff. Leave it all behind. Delete all electronic data. Don't wipe their phone before you return it to them. That's always bad too. People make that mistake. But it's like take nothing with you. Leave the right way.
And I want to segue this into something that I know that is sort of near and dear to your heart because litigation is a rich man's game, rich person's game. And so there's a book that I'm reading right now to a certain 9-year-old that was really rich guy. Warren Buffett read it when he was a kid, and so she wanted to read it as well. And so we read that at night, but it's written in 1937. And you would be amazed at the abuse or the pronoun. Just how imbalanced it is, and it's And I read it and I try to change the pronouns to make them to try. I try to do that appropriate. So I'm a lot more cognizant of my pronoun game these days. But getting back to it, because litigation is for rich people. It really is. Civil litigation in many ways is a luxury. Talk about how you are able to take clients with really difficult employment disputes, navigating the litigation waters, maybe, God willing, avoiding litigation.
Right. So the goal always is to solve the problem and to try and find a resolution. And of course, the resolution is usually financial. But I'll take cases hourly. I'll take cases on a contingent fee if I think I can justify taking it on a contingent fee. But always what you're trying to do is find a resolution for people. And I tell my clients all the time, sometimes the best thing I do for people is when they come in and consult with me is I tell them they don't have a case. So then they have peace of mind and they can close the door and move on. But I tell them all the time, we're always going to be looking for a resolution. Often what I say is a fair resolution, my clients may not think is particularly fair, and then I have to explain why it is. But we're always trying to find a way to solve the problem.
Something that I think that would be particularly frustrating, you tell me, is when you win a case or you get a great resolution that you know is a good one relative to everything that you've done in the past and the client's still upset. I deal with it in criminal law too, but people, it's hard to explain to folks that, look, when the jury comes back, or if they come back and do this, there's no blue ribbon at the end of this.
Right.
Even if we were to go to a jury and the jury were to tell us that we were completely right, they're going to walk out of here and say the jury was idiots. Right. They're not coming over here and apologizing. We're not getting the county fair ribbon here. None of that happens. Right. How do you manage clients' expectations? How do you get them to walk away happy in a situation where it's really hard to do that?
I always tell my clients, anytime you get someone to write you a check, that's a win, no matter what size the check is, because they didn't want to write it. So that's already a win, even if it's much smaller than you want. And we just spend a lot of time walking through it and, explaining the process. And one of the hardest things is clients who want an apology, because that's the thing I'm least likely to be able to get. They want some admission and an apology, and it's like, we're not going to get that. We can get you some money, but we're not going to get the apology. And so it's just spending a lot of time. And the other thing that helps is time. People right after they've been fired are very, very emotional. 6 months down the road, 9 months down the road, 18 months down the road, time does heal. And so that helps as well. It gives them a little bit more perspective. But we just have to redefine what a win is in their mind. And one of the problems we have, again, is and I just told you about those verdicts from Washington and Kansas, is you read these headlines, but what we haven't talked about are statutory damage caps. And so that $6 million compensatory damage award in Washington is going to be reduced to $300,000 under law, because that's the maximum award for that particular type of claim. And so nobody knows, other than lawyers, about these damage caps. And so they're very shocked because they've read these jury verdicts and these headlines, and they're very shocked to learn, but that got written down later, and they only got $300,000 for that.
And not only that, but you also said earlier, 60% of cases lose on summary judgment.
Right.
So people just see the big number and they see the big highlight, and then they paint with a broad brush. Well, there's just too many frivolous lawsuits. But if you said, well, here's a case where this guy did this and he did this and he did this, and they couldn't even get a trial. Right. Because a judge poured them out. And that is far more likely a result than your mega verdict over there. Right. One thing I want to talk about before they throw us out of here imminently is retaliation, because we touched on it before. But talk a little bit why retaliation is so prevalent, and how can you tell it's there? It is prevalent because, again, everyone hates a rat. So if I think you've been discriminating against me and I go complain to the company about you,
I'm not happy with you because you caused this big spotlight to be shining down on me, and I've had to defend myself. And I may ultimately be okay with the company, but who am I mad at? I'm mad at you.
Right.
I want you gone, and I'm going to find a way to get you gone. Or if I can't immediately fire you, I might find, death of 1,000 cuts, 1,000 ways to make you miserable. Give you the bad performance review. I change your hours. I give you an inconvenient schedule. And retaliation happens all of the time. So what we look for is, once you've complained about someone, what we're looking for are the changes in the work environment and the treatment towards you, and to see if it's worse. Mm-hmm. And it's there. It's worse usually. So it happens all of the time.
I tell people very frequently that I work with that I do not like a rat.
Right.
Well, no, I got that wrong. Nobody likes a rat except me.
Right.
So I'm like, tell me what they did. So, but interestingly, there's a lot to that because nobody likes being called a racist.
Right.
And so, and what happens is, and we have there are certain categories of complaints that are protected complaints, and there's some that are just belly aching.
Right.
Or they may as well be under the law. If you come in and you say, you guys are discriminating against me because I'm Canadian, that would be a protected complaint, right?
Right.
Because that's based on national origin.
Right.
And manager says, well, nobody calls me a racist, or nobody calls me this, so I'm not going to, and maybe the manager doesn't care that he's from Canada or she's from Canada, but then they do exactly what you're saying, and now I have to defend myself. You've called me a racist to my face. You think you know the rules. I'm going to show you who knows the rules.
Right.
You were not here at 8:02 this morning.
Right.
You came in late.
Right.
You didn't put the cover on your TPS report. You ever watch Office Space?
I don't.
That's a very big deal at our office.
Okay, putting the cover on.
That movie.
Okay.
That movie. There's a handful of them.
Okay. Yeah, but no, that's exactly it. And the irony is, particularly, is companies tell you if bad things are happening. Tell us. They encourage you to report. They promise you protection.
But they don't want to know.
Yeah, right. They promise you protection from retaliation, and then they don't really give it to you.
Well, they're people.
Right.
They are all people, and organizations and people have a funny way of thinking collectively.
Right.
Because again, I don't like being called names. I don't like being told that. And I always joke too. Oh, I love criticism. Nobody likes, and I'm sorry, and I'm sorry, there are people who are better at it, at accepting criticism than others.
Right.
But there's certain criticism that I just think is awful, and I'm gonna be angry at you. And I'll tell you this much too. One of the things at the DA's office when I was a prosecutor, just being in a big bureaucratic environment, there were many relationships that I had that I've with a lot of really great people, a lot of really cool people, a lot of very competent people, and some rocks in my shoes that I carry around is, but there was that time that you did this. There was that time that you kind of knifed me in the back, and I am never going to forget that.
Right. See, you remember, and they say revenge is a dish best served cold.
Star Trek II, The Wrath of Khan.
Yeah.
That's where that comes from.
Yeah. So it's, retaliation is a huge problem, and we see it all of the time. And what I love more than anything is when people come to me while they still work for a company so that we can raise the complaint before they've been fired. Mm-hmm. And of course, companies hate nothing more than having a current employee filing a complaint. They hate that.
Sure.
Because then they worry, like, what do I do? If I fire them, then boom, there's the retaliation.
Then they walk on eggshells around that person.
Right. But so I love more than anything having a current employee come in with a legitimate complaint. It's got to be legitimate. But if there's something going on, then we can raise that while they're still there and hopefully stop them from being fired, or if not, get them some type of package to move on.
Right.
So.
Parting words to Lawyer Podcast Nation. Yours.
What I always tell, if you're an employer, just be fair. People can understand being fired. They don't like it, but if they feel like they've been treated fairly, they're not going to call me. But for those who treat people unfairly, I love it when their employees call me. So, Karen Fitzgerald at Fitzgerald Law.
All right, there we go. This wraps up another ridiculously successful episode. So, thank you, everybody, and we'll see you. I don't know if we'll see you next week or not. I don't think so, or the week after.